Now, let me ask you a question about settled law. If the holding in the Supreme Court means that it's settled, do you believe that Gonzalez versus Carhart, upholding the partial birth abortion ban, is settled law?
All precedent of the Supreme Court I consider settled law, subject to the deference the doctrine of stare decisis would counsel.
As you know, Judge, the landmark case of Griswold versus Connecticut guarantees that there is a fundamental constitutional right to privacy as it applies to contraception. Do you agree with that? In your opinion, is that settled law?
That is the precedent of the court, so it is settled law.
Is there a general constitutional right to privacy, and where is the right to privacy, in your opinion, found in the Constitution?
There is a right of privacy. The court has found it in various places in the Constitution, has recognized rights under those various provisions of the Constitution. It's found it in the Fourth Amendment's right and prohibition against unreasonable search and seizures. Most commonly, it's considered, I shouldn't say most commonly because search and seizure cases are quite frequent before the court, but it's also found in the 14th Amendment of the Constitution when it is considered in the context of the liberty interests protected by the Due Process Clause of the Constitution.
All right. Judge, the court's ruling about the right to privacy in Griswold laid the foundation for Roe versus Wade. In your opinion, is Roe settled law?
The court's decision in Planned Parenthood versus Casey reaffirmed the core holding of Roe. That is the precedent of the court and settled in terms of the holding of the court.
Do you agree with Justices of Souter, O'Connor, and Kennedy in their opinion in Casey, which reaffirmed the core holding in Roe?
As I said, Casey reaffirmed the holding in Roe. That is the Supreme Court's settled interpretation of what the core holding is and its reaffirmance of it.
All right.
So let me ask you, in a difficult area of the law, a question. The Supreme Court has decided on more than 7 occasions that the law cannot put a woman's health at risk. It said it in Roe in 73, in Danforth in 76, in Planned Parenthood in 83, in Thornburg in 86, in Casey in 92, in Carhart in 2000, and in Ayotte in 2006. With both Justices Roberts and Alito on the court, however, this rule seems to have changed because in 2007, in Carhart 2, the court essentially removed this basic constitutional right from women. Now here's my question. When there are multiple precedents and a question arises, are all the previous decisions discarded, or should the court re-examine all the cases on point?
It's somewhat difficult to answer that question because before the court in any one case is this particular factual situation. And so how the court's precedents apply to that unique factual situation, because often what comes before the court is something that's different than its prior decision. Not always, but often. In the Carhart case, the court looked to its precedents, and as I understood that case, it was deciding a different question, which was whether there were other means, safer means, and equally effective means for a woman to exercise her right than the procedure at issue in that case. That was, I don't believe, a rejection of its prior precedents. Its prior precedents are still the precedents of the court. the health and welfare of a woman must be a compelling consideration.
So you believe that the health of the woman still exists?
It is
As a
part.
criteria.
You mentioned many cases. It has been a part of the court's jurisprudence and a part of its precedents. Those precedents must be given deference in any situation that arises before the court.
Thank you very much. I appreciate that.